in which the crime has been committed. He may not be giving in detail the manner of the crime, but he must be giving at least some clue that what crime has been committed and in what way. So a cryptic message recording an occurrence cannot be termed as an FIR. Then there is Ravi Shankar Manji versus State of Jharkhand, AIR 2009. Ravi Shankar Manji versus State of Jharkhand, AIR 2009. In this case, it was held that a mere information received on phone. If somebody phones, somebody make a call on his mobile to the SHO or to the police station, and without he's not giving any details of the offense, as he's not giving any identity of the accused to the police. He's just saying that this offense has been taken place in this area, and he's not giving any injuries caused to the victim. He's telling nothing in this message. So it may not be treated as an FIR. Then there is case of Ram Das versus State of Maharashtra, AIR 2007 Supreme Court. Ram Das versus State of Maharashtra, AIR 2007 Supreme Court. In this case, it was held that mere delay in lodging the FIR is not necessarily fatal to the case of the prosecution. FIR should be prompt. It should be, once the offense has been done, FIR should be prompt. But just mere delay on the part of the maker of the FIR, on the part of the informer, it may be due to certain causes, certain genuine causes. He may be too late. But it depends upon case to case. It's not a very hard and fast rule that this much time should be taken by the informer to record an FIR. Just a delay, not necessarily fatal to the case. However, the court may take delay into consideration as it makes the case of accused strong. The more the delay in registering the FIR, the more the case of the accused becomes strong. A doubt is created in the mind of the court. Why the FIR is delayed? Is before registering the FIR, was there any consultation? Why there is some deliberation before registering an FIR? Because you see, registering the FIR, once the offense has been made, there is some offense. The FIR should be spontaneous. It should be spontaneous. It should not be because of any deliberation by the informer, or he should not consult any advocate before that. It should be spontaneous. The more spontaneous the FIR, the more it will be strong, and the more the prosecution case will become strong. Otherwise, the accused will get the benefit of doubt. So FIR must be prompt. There should not be any delay, or there should not be any deliberation or calculation before lodging an FIR. This is the general rule. But this rule does not apply on every case. This rule does not apply on every case. For example, rape case. In rape case, the parents of the girl doesn't come forward very easily because the honor of the family is at stake. So in rape cases, Supreme Court have told in many cases that even delay of even many months, 3 months or 2 months, that is also not necessarily fatal to the case, because in the Indian circumstances, rape is treated as a stigma on the family of the victim. So there a delay cannot be of very much importance, and the registration of FIR will be deemed to be proper. So as I have already told you, FIR should be basically spontaneous along with all the circumstances of the case, all the circumstances of the cognizable offense. So whether the FIR is lodged belatedly, whether the FIR is lodged in a delay or not, it depends upon case to case, and it's just a pure question of fact. The judge, while deciding this question, whether the FIR is delayed or not, before deciding this question, the judge should keep in mind the explanation furnished by the prosecution about the reason for delay. So judge will ask the prosecutor that why there is delay of this much time. The offense has been committed at this time, and FIR has been registered after 2 days. Why there has been a delay? The prosecution or the prosecutor has to explain to the judge why there has been delay. If he properly explains the reason of delay of FIR and the judge accepts that reason, then it's okay. The case will move further. Otherwise, delay can be very much strong evidence of a fake FIR. So and the more the delay, more the accused's case becomes stronger, more the prosecution case becomes weaker. So FIR in every case must be prompt. But in rape cases or some other cases, it depends upon case to case. So there is no mathematical formula or hard and fast rule regarding the fixed time within which an FIR can be lodged. It depends upon case to case. And for example, in rape cases, generally the FIR is lodged belatedly because I've already told you the parents and relatives of the victim, girl, may find it very difficult because to immediately approach the police because they are in shock. They are in shock and honor of the family is at stake. So it is natural and does not mean that FIR is deliberated or filed with after consultation or the information is incorrect. That's not the case. Even in state of Maharashtra versus Suresh, 1997. State of Maharashtra versus Suresh, 1997. In this case, it was held that the delay in lodging of FIR in a case of rape is not very material. This is a very important case. Then in the case of Jatinder Kumar versus State of Haryana, AIR 2012. Jatinder Kumar versus State of Haryana, AIR 2012 Supreme Court case. It was held by the Supreme Court that the primary object of the FIR is to set the criminal law into motion, as I have already told you in the earlier case, and it may not be possible to give every minute detail with precision in FIR. So FIR itself is not the full proof of the case. FIR is not a pakka saboot. FIR is not the substantial evidence of the case. Just on the basis of FIR, you cannot convict an accused. FIR should be supported by reliable, cogent evidence. Whatever he says in examination in chief, whatever he says in cross-examination, that is the proper evidence, that is the proper method. FIR can be helpful there in the trial to corroborate whatever he is saying in the court, because it's the previous statement as given under Evidence Act that I will be telling you afterwards in some other case. So it's just a piece of evidence and it can be used to corroborate or contradict the maker of the FIR, the witness who comes as a witness in the court, and whatever he says in the court, that statement can be corroborated by the prosecution or by the accused defense lawyer in the trial. Whether FIR can be registered by telephone or by mobile, I have already told you, a message sent by a mobile or telephone to the police officer and recorded by him in his station diary, which discloses an information regarding a cognizable offence, it will amount to an FIR, and this has been held in Shyam Dogria versus State 1953. Shyam Dogria versus State 1953. But a cryptic, a hidden, not easily understood. So a cryptic means hidden or not easily understood message and anonymous telephone message. The maker of the message, the person who is calling the police, he is not disclosing himself. He is not disclosing his real name. So he is very anonymous. And he is not clearly specifying what cognizable offence has been done. And it cannot be, the police may not treat it as an FIR, and the police may not register an FIR, even if such information was given by the person and he tries to explain the police. But if it's a cryptic message and he's not